contingent contract, or you can also call them conditional contract. Now these contingent contract, why they are called contingent? Because they depends on happening or non-happening of a particular event. That's why they are called contingent. So let's look at them in detail. Section 1 to 36 of Indian Contract Act 1872 speaks about contingent contract. So what are the contingent contract? Essential characteristics, rules regarding them, and even the line of difference between wagering agreement and contingent contract we'll be covering for today. Contingent contract has been defined in the section 31. A contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. That's why it depends on happening and non-happening of a particular event. For example, A contracts to pay B rupees 10,000 if B house is burned. अगर B का घर जल जाएगा तो A B को 10,000 रुपए देगा. So this is a contingent contract. Next, what are the essential elements for this particular contingent contract? So first is there should be existence of a contingency, like happening or non-happening of some event in future. Contingency must be uncertain. Now this is not definite that it will happen or it will not happen. The event must be collateral, incidental to the contract. Event must be connected to the contract. Now what are the rules with regard to contingent contract? Section 32 provides that contingent contract to do or not to do anything if any uncertain future event happens can't be enforced by law unless and until that event has happened. If the event becomes impossible, such contract also becomes void. Thus, promisor will not be liable to perform the promise until the certain event has happened. Now, this whole contract depends on the happening or non-happening of the event. Without happening and non-happening of this event, this contract is not possible. For example, Raj makes a contract with Hari to buy Hari's house if Sham dies before Raj. अगर Sham Raj के पहले मर जाता है तो वो हरी का घर खरीदेगा. This contract can't be enforced until the death of Sham. Mohit makes a contract with Shiv to sell a horse to Shiv at a specified price. If Ajay, to whom the horse has been offered, refuses to buy it, the contract can't be enforced by law unless and until Ajay refuses to buy the horse. Next, Ravi contracts to pay Nitin a sum of money. When Nitin marries Anita, Anita dies without being married to Nitin. Now this contract becomes void. Rule number 2, contract dependent on happening or non-happening of a particular event. Section 33 provides contingent contract to do or not to do anything if any uncertain future event does not happen, can be enforced when the happening of event becomes impossible or not before. Contracts can be enforced only when happening of the event becomes impossible. Rohit agrees to pay Nikhil a sum of money if a certain ship does not return. The ship is sunk. The contract can only be enforced when the ship sinks and not before that. According to section 34, if the future contingent event consists of how a person will act at an unspecified time, that event shall be considered to have become impossible if such person does anything which renders it impossible that he should do so act within any definite time or otherwise than under further contingencies. The contract becomes void when such person does anything to make the event impossible. Mahesh agrees to pay Sachin a sum of money if Sachin marries Neha. Neha marries Parson. The marriage of Sachin to Neha must now be considered impossible. Although it is possible that person may die and Neha may afterwards marry Sachin. Section 35, contingent contract to do or not to do anything as unspecified uncertain event does not happen within a fixed time may be enforced if the event does not happen or it happening becomes impossible before the expiry of a time. Manish will pay amount rupees 4,000 if a certain ship does not return within a year. The contract may be enforced if the ship does not return within a year or if the ship is burned. Then Section 35, contingent contract to do or not to do anything if a specified uncertain event happens within a fixed time, becomes void if the event does not happen or its happening becomes impossible before the expiry of that time. For example, Ramesh promises to pay Suresh a certain sum of money if train will arrive at its scheduled time. The contract may be enforced if train arrives at that particular correct time and becomes void if the train gets delayed or doesn't even arrive. Next, contingent agreement to do or not to do anything if any impossible event happens are void, whether or not the fact is known to the parties under section 36. For example, Aman agrees to pay rupees 1000 to Vinay if two straight lines should enclose a space. The agreement is void. Nitin agreed to pay 1000 to Manish if Manish will marry Nitin's daughter Manju. Manju was dead at the time of agreement, so the agreement is void. Contingent contract and wagering agreement. How do they differ? Are they the same? No. All contracts are agreement, but all agreements are not contract because for agreements to become a contract, they should satisfy all the essential elements of a legal valid contract under section 10. Next we have is wagering agreement. Literally the word wager. What it means? It means a bet. Something to be lost or won on the result of a doubtful issue. It is a promise to give money or money's worth upon the determination or uncertainment of an unspecified, uncertain event. The section does not define wager. Section 30 states that agreements by way of wager are void, and no suit shall be brought for recovering anything alleged to be won on any wager, or entrusted to any person to abide the result of any game or other uncertain event on which any wager is made. For instance, if A and B mutually agree that if it rains today, I'll pay rupees 100 to B, and if it does not rain, B will pay rupees 100 to me. It is essential to a wagering contract that each party under it may either win or lose, depending on the issue of the event and remaining uncertain until that issue is known. So now, a contract is a wager if the event is uncertain, not only because it is a future event, but because it is not yet known to the parties. Secondly, the parties must have no interest in the events happening or non-happening except winning or losing the bet laid between them. Wager agreements are considered as illegal in the states of Maharashtra and Gujarat. Next, what are the differences between these wagering agreement and contingent contract? The wagering agreement, there is a reciprocal promise, but in contingent, there is no reciprocal promise. Wagering agreements are void contract, contingent are valid. In wagering agreement, future event is essential to the contract, but in contingent, future contract is collateral to the contract. Under wagering, it's always of a contingent nature, but in contingent, it may not be of wagering nature. Under wagering agreement, parties have no interest in the subject matter, but in contingent, parties may have any interest in the subject matter. So there are some specific cases like commercial transaction, lotteries, competition prizes, insurance contract. They all are permitted as such for wagering agreements. That's all for this particular session regarding contingent contract and the line of differences between wagering agreement and contingent contract.